I'm Deputy District Attorney Anne-Marie Rosa. Dr. Fields has invited me to class today to teach you about direct and circumstantial evidence. If you watch those law shows on TV, you might think circumstantial evidence has gotten a really bad reputation. You know, those scenes where the defense lawyer goes to the DA and says, "All you got is circumstantial evidence." The implication is that you don't have a very strong case. The truth is, the law says that circumstantial and direct evidence are equally valid as a method of proof, and a jury is permitted to convict a defendant based purely on circumstantial evidence if they find that evidence convincing beyond a reasonable doubt. Let me take a moment and explain the distinction between circumstantial and direct evidence. I'll give you an example. A witness goes into court, points at the defendant, and says, "I saw that guy commit a robbery. I was standing in line at the ATM, and I saw him go up to the victim, point a gun, and steal the victim's wallet." That would be an example of direct evidence because the witness purports to have directly observed the crime. Now let me change the example. Suppose a police officer comes into court and says, "I never actually saw the robbery take place, but I got a radio call of a robbery at the ATM. I saw a person fitting the description of the suspect running away from the area where the robbery occurred. I apprehended the suspect, and I found the victim's ID and credit card in his pocket." That would be an example of circumstantial evidence. It's a set of circumstances from which one could infer that the suspect committed the robbery. As you can see, circumstantial evidence can be very convincing. Criminal defense attorneys will try and show that there may be an alternate explanation in circumstantial evidence cases. For example, that somebody else committed the robbery, threw down the victim's wallet, and their client merely took the credit card and license from the wallet and ran off, but did not actually commit the robbery. It's my job as a deputy DA to rebut that theory. I'm DDA Rosa, and that is your lesson on direct and circumstantial evidence.